So in addition to judging, what was my role as a judge in the court? I became quite involved from the very beginning in the actual administration of things. As I said, I have no pretensions to academic qualifications. And in fact, when I went to Strasburg, I was well aware of the fact that there were a great many very distinguished professors there. And I have to confess, I was a little nervous about how I would get on with them. But in fact, they became my best friends on the court. And we learned an awful lot from each other. I think I learned a heck of a lot more from them than they did from me. But nonetheless, I learned a great deal. And in fact, sad to say that the then president of the court, who became probably my best friend on the court, President Lucius Wildhaber, only died a few days ago. I was very sorry to see that. A wonderful gentleman, a fine lawyer, a former rector of Basel University. One of his predecessors was Erasmus. So his loss is a sad loss to the world of the law and of human rights. But anyway, I wound up getting involved in a lot of the administration of the court. I chaired the Committee on the Status and Conditions of Judges. I chaired the IT Committee and also the Language Training Committee. It's a bilingual court. And for most of the judges, they have to operate in 2 foreign languages. Only the Francophones and the Anglophones have the luxury of operating in 1 national language, their own, and 1 foreign language. So much less pressure on us than there was on the other. At one stage, near the end, I had 30 judges studying English or French at different levels. And I greatly admired their commitment to the cause by going back to learning a language again, which was not easy for them. I was also a member of the Library Committee and the Rules Committee. What was it like? Well, it was a marvelous opportunity. As I said at the outset, we all found it tremendously exciting to be involved in such a great endeavour and such an historic one. And I treasure the 9 years I spent on the court in Strasbourg as being, I think, probably the highlight of my career. There was a great atmosphere in the court. It was a fine place to work, and you were obliged to reside at the seat of the court. That's Strasbourg, and Strasbourg turned out to be one of the most beautiful cities in Europe, if not indeed in the world, dating from Roman times when it was called Argentoratum. There were so many extraordinary stories that arose out of our study of the legal systems and cultures of what turned out to be 47 countries in the end. At this stage, I'm going to mention the webcasting project because it was an Irish project from pretty much the start. I'll explain what I mean by that in a few moments. So perhaps this would be a good opportunity to play the piece that you've chosen. It gives people a sense, a feel of just what the court is like, what it's like to be there.
Zia, could you play the video?
Yes, ma'am.
Please.
There doesn't appear to be any sound.
Volume.
The applications were allocated to a section of the court pursuant to Rule 52, paragraph 1 of the Rules of Court. These applications were respectively communicated and re-communicated to the government on 4 March 2008. On 19 May 2009, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber, none of the parties having objected. The Turkish government are represented by their agent, Mr. Nekatigil, assisted by Sir Michael Wood, counsel, and Mr. Talmon, Mr. Karbakak, Mr. Uras, Mr. Ezener, Madame Akshai, Ms. Akuzlu Ailange, Ms. Akpak, and Mr. Furlong, advisors. The applicants are represented by Mr. David Anderson, QC, Mr. Dimitriades, Mr. Markides, Mr. Cleridis, Ms. Vokidou Liazides, Mr. Neocleus, counsel, assisted by Ms. Lolisides, Mr. Paraskeva, Mr. Poliviu, Mr. Arakelian, Mr. Angelidis, Mr. Liazidis, and Mr. Leach, advisors. The intervening government, the Republic of Cyprus, are represented by their agent, Mr. Cleridis, assisted by Lord Lester of Fernhill, QC, Mr. Lowe, QC, Mr. Saini, QC, Mr. Richards, and Ms. Ioannidis, counsel. I welcome the applicants and the representatives of the parties in the name of the court. I would also like to welcome several delegations of judges visiting the court today, from the African Court of Human and People's Rights, from the French Conseil d'État, from the French judiciary, as well as from the Russian Federation and Bosnia-Herzegovina. Having consulted the agent of the government and the representatives of the applicants, I have determined the order of addresses as follows. Sir Michael Wood for the Turkish government will speak first, and then Mr. Anderson and Mr. Dimitriades for the applicants, followed by Mr. Lowe and Mr. Saini for the intervening government of the Republic of Cyprus. I would explain that in addition to interpreting in the 2 official languages of the court, English and French, interpreting into Bosnian has been authorized for the benefit of a group of judges from Bosnia and Herzegovina who are on a study visit to the court. Such interpreting is not arranged by the court, and no transcription of the oral translation will be included in the official record of the proceedings. I call Sir Michael Wood. Sir Michael, please.
Thank you, Mr. President.
Can we hear a little bit of this gentleman's submission to the court just for a few moments? I don't want to use up too much time, but as I think I pointed out, the British judges, the British barristers invariably were the best. That's why you could see the very odd thing that the Turkish government actually briefed a British barrister to appear. The Irish hardly ever get there, and I'm sure the Indians would have been just as good because you have professional advocates, but most advocacy in the court was of a very poor standard, whereas the British are the best. So it's worth listening to them just for a few moments.
Zia, can you continue with the video, please?
Okay, ma'am.
जो आपने खोला, you play it, please.
And to do so on behalf of Turkey. Mr. President, in its decision in Zinidis Orestes, the court asked Turkey to establish a domestic remedy for all property claims in northern Cyprus. It identified 5 changes that were needed in existing law. First, to introduce the possibility of restitution of immovable property. Second, the possibility of redress for loss of movable property. Third, an international element in the composition of the Immovable Property Commission. I shall refer to the Commission in future as the IPC. Fourth, damages for non-pecuniary loss. And fifth, that the law should apply retrospectively. Turkey complied fully with the court's request by adopting Law Number 67 of 2005. The court then noted in its December 2006 judgment that the new law in principle satisfied all these requirements. At the same time, however, the Greek Cypriot authorities have consistently sought to disrupt the operation of this remedy, which they persist in describing as illegal. A central fact in the 8 applications before you today is that not one of the applicants has taken any step to exhaust the available domestic remedies. They have all declined to do so, notwithstanding the findings of this court in the Zenidis Arestis pilot proceedings. As you will recall, the judgment on the merits in that case, in that judgment, the court suspended consideration of all applications deriving from the same general cause, including the 8 before you today. Then, in its just satisfaction judgment, the court held, and I quote, that the new compensation and restitution mechanism in principle has taken care of the requirements of the decision of the court on admissibility and the judgment on the merits. I need hardly stress, Mr. President, that the present proceedings are important, not just for the 8 applications, but for all applications deriving from the same general cause. There are, we understand, about 1,475 pending applications, and there could well be more to come in the future. Many involve more than one applicant. In an attempt to justify their passive stance, the applicants
you could put this as soon as you want, in order to give time to finish and for questions and answers.
Okay.
So, am I back live again for continuing this talk?
Yes, please.
Yeah.
Yes, sir.
Well, that's a very interesting choice of case, because it is a follow-on to the Cyprus versus Turkey case that I referred to earlier, and you can see again here arises the issue of the obligation to exhaust domestic remedies, which is so significant. It's very interesting for me to see the judges walking out there, because it's 2009, it's only 2 years after I left, and I recognize them all. They're all now retired from the court because their terms of office are up. The 2 judges sitting at the front there were the president of the court, Jean-Paul Costa from France, and Christos Rosakis, the vice president of the court, 2 great lawyers and very, very good friends of mine. The reason that I thought it would be nice for you to see something of the webcasting project and to see a case being shown there is because it became probably the signature project of the IT working group that I chaired. When I was asked at the beginning of 1998 to chair this body, there was one issue that we were really concerned with, and that was ensuring that we got our own IT system. And we had to fight hard for that administratively, because the Council of Europe system we did not think was good enough for the huge task that lay ahead, and we were fortunately able to achieve that. The second project that emerged was, I remember that the head of IT, who happened to be a man from Northern Ireland called John Hunter, he raised the possibility of broadcasting on the internet the public hearings of the court. Myself and my colleague Hannah Sophie Greve, the judge from Norway, were very excited by that prospect. We thought that was a marvelous idea. We had in our head the idea of ordinary folk in the middle of the steppes of Russia being able to go to a library nearby and to see on some internet connection their government being called to account before an international tribunal, and not just Russia but many, many countries, because the overwhelming majority of people could never get to Strasburg. So anyway, this project took a very, very long time. We had first to convince the judges, who were all suffering from a kind of post-O.J. Simpson syndrome, horrified at what turned out to be, as they called it frequently, a circus, and they didn't want anything like that to occur. But gradually we worked hard on this project. We even went to The Hague to see the ICTY in operation and how they did their system. And not long before I left, we managed to persuade the judges to try out a pilot project in which we would broadcast the public hearings of the court. A key element of that we were very conscious of from our visit to the ICTY was security. The mention of the names of witnesses who could potentially disappear was something very important. So one of the rules was that the first question really that a deliberation body should ask itself after a hearing that had been videoed was, is there anything in that video that should not be broadcast publicly? And if there is, delete it. So morning hearings were only available in the afternoon for security purposes. We finally had the pilot project and it was hugely impressive. I think the judges who were reluctant but gave the pilot project a go all came around to the view that this was a great idea. And one of the reasons I wanted to mention it here, one of the number of reasons I wanted to mention it here today was because my colleague from Germany, Professor Georg Ress, who was a teacher of outstanding experience, he said to me after we'd done the first trial project of a hearing, he said to me, that could be one of the great teaching tools of the world. And I hope that it may be of use for students themselves. You can simply just Google webcasting and the Court of Human Rights and up will pop the most recent case and you can get a look at what is actually going on. Students might be interested to note that the QC who spoke there was speaking slowly and clearly, because he is bearing in mind that he's speaking to people, for most of whom English is not their first language. And we sometimes got advocates who spoke so fast that no one could follow what they were saying, and even people who were extremely good at the language. So very good advice for those who may wind up as advocates. Clarity and pitching to your voice to the audience that you are actually addressing. The webcasting project became somewhat controversial, of course, with countries who were not very happy with the idea that they might be shown in their home countries being held to account before an international tribunal. And at the very last minute, there was an attempt made to torpedo this project on the usual grounds that this would be far too expensive and money was always in short supply in Strasburg. Fortunately, this had been foreseen, and I had got the agreement of the Irish government that they would fund entirely the installation of the webcasting system. That means the studios, the cameras, everything. And they did that, and they have paid for the annual maintenance of the webcasting system every year since, including, to their great credit, I think, during the terrible years of the economic crash that befell us from about 2009-10 onwards. And that continues today. And in honor of their commitment and engagement, I insisted that there is a little logo at the bottom which says the webcasting project is financed by Ireland Aid, and I'm delighted that they get the credit for that. The webcasting system gets, I've forgotten exactly how many million hits a year, but it is absolutely colossal. So that was a great success, And as I said, I'm very proud to say that it was an Irish project from end to finish. John Hunter being the man who suggested it at the very beginning, and the Irish government being the ones who financed it at the very end. Anyway, I don't want to go on too long because I want to leave time for the questions and answers, but I just thought I'd bring you up to date with what exactly is the state of play at the present moment in terms of development. Well, the new president of the Court of Human Rights, Judge Sicilianos, in his opening of the year 2020, described the application in the case of Mamadov versus Azerbaijan, in which a judgment was delivered on the 29th of May 2019 as probably the most significant event in the court of 2019. And this was the implementation of a part of Protocol number 16 to the Convention, which provides for infringement proceedings to be brought against countries against whom a judgment was given and whom the Committee of Ministers felt had not implemented it. And where the government, in this case Azerbaijan, was disputing that and saying we have implemented it, and a sort of impasse was reached, the enforcement procedure was brought about, the infringement procedure was brought about with the aim of addressing that gap. That was being talked about when I was there, and it was somewhat controversial because the case law of the court is so colossal that it has grave difficulties in actually being able to deal with its caseload. So any extra work would be likely to be detrimental to the real job of the court, which is to hear the cases of individuals and decide them. Along with the infringement procedure in Protocol 16 was also an issue that was discussed a lot while I was there, and that is the court giving advisory opinions to courts, to the top court in a particular country when it was faced with a convention issue. And much like the reference to the EU, again, the argument against that was overloading the court with different functions makes it difficult for it to do its main job. It's a very difficult balancing act to know where the right thing to do actually lies, but one does the best one can. Protocol number 15 has not yet come into effect. It's a protocol that was thought, as with 16, to complete the so-called Interlaken process of trying to bring up to date, to improve in every possible way the working of the court. Protocol 15 introduced a reference to the principle of subsidiarity and the doctrine of margin of appreciation into the preamble of the convention, more to just indicate how important it is. It proposes to shorten to 4 months the time limit for making an application. It amends the significant disadvantage admissibility criterion by removing the condition that no case may be rejected on this ground which has not been duly considered by a domestic tribunal. It removes the party's right to object to the relinquishment of jurisdiction by the Chamber to the Grand Chamber, and it replaces certain provisions regarding the age limit that you don't really need to worry about. More up to date is that the latest interstate case that exists has just been lodged with the European Court of Human Rights by the Netherlands against Russia, concerning the downing of Malaysia Airlines flight MH17. The application was registered as 28525/20, and it concerns the shooting down of the plane over the eastern Ukraine on the 17th of July 2014, killing 298 persons, including 196 Dutch nationals. According to the government of the Netherlands, the plane was shot down by a missile, surface-to-air missile, which belonged to and was provided by the Russian Federation. So it'll be interesting to see how that case develops. To finish up, just a reference to boring statistics, because for us they are, as I said, jaw-dropping. In 2019, there were 59,800 pending applications. There were 328 judgments delivered by chambers. There was 545 judgments delivered by committees of 3 judges, 33,288 applications declared inadmissible or struck out by single judge formations. There was 5,002 applications declared inadmissible or struck out by committees of 3. There were 11 oral hearings held by the Grand Chamber, 11 judgments delivered by the Grand Chamber, 5 cases were relinquished to the Grand Chamber, 8 were referred to the Grand Chamber, 190 applications were declared inadmissible or struck out by chambers. There were 2 advisory opinion requests and there was 1 advisory opinion delivered. So there it is. That's my take on the European Court of Human Rights, where I came from, how I got to my initial experience there. It's been the experience of my professional life. I am delighted to have had the opportunity to do it. I have not mentioned one of the key elements to, I think, the success of the Court of Human Rights, and that is the registry. That is the permanent lawyers who work there and who do outstanding work. I always was lost in admiration for their work ethic and for the quality of the work that they did. They draft the judgments and the drafts are then dealt with by committees of judges who determine whether or not that expresses exactly what they want. The reason for that is because, except for the Anglophones and the Francophones, everyone would be drafting judgments in a language other than their own, and that would be very difficult. It makes, I think, the judgments of the Court of Human Rights very easy to read because they all follow a very similar pattern and they all have a very high level of quality about them. So I hope that's been of interest to you. Thank you very much for your attention, and I'd be delighted to answer any questions, but just no hard ones, please.
Thank you very much, Justice Hedigan, for this wonderful talk. I'm sure the audience is waiting to ask questions.